Welcome to our webinar on safe practices in hiring. This is the third in a series of webinars that the Labor and Employment and Human Resources Practice Group at the Wagner Law Group will be offering. This presentation will last about 30 minutes, and the slides from the webinar will be available on the Wagner Law Group website. Let me introduce David Gabor of Counsel with the Wagner Law Group. David is a recognized leader in the employment law field. He represents clients in litigation, the negotiation and drafting of contracts, handling compliance issues, the creation of corporate infrastructure, the drafting of policies, training of employees, and leading companies towards organizational excellence. Welcome, David.
Thank you, Barbara, and hello, everybody, and thank you for attending the program today. Peter Drucker said, "So much of what we call management consists in making it difficult for people to work." I thought that quote was appropriate because what the government has done, the federal, state, and local level, in the employer-employee arena, is making it so much more difficult for companies. In 2011, the EEOC boasts that nearly 100,000 charges were filed and that they recovered nearly $500 million from employers. And that's only a small portion of the litigation that took place in 2011. So the goal for the program today is to talk about some of the laws governing the hiring and promotion of employees and ways that you can incorporate these laws into your practice. We're going to talk about hiring and promotion policies, job descriptions, job applications, the interview process, background checks, and offers of employment. The major statutes governing the employer-employee relationship are Title VII, the ADEA, the ADA, and they cover gender, race, religion, ethnicity, national origin, military status, age, and disability. There are also laws on the state level that cover sexual orientation and in some states, gender identity. In court cases, there is direct and circumstantial evidence. Direct evidence would be, for example, a memo that says, make the next couple of hires young people, our workforce is getting long in the tooth, or don't hire any more working mothers, they're unreliable, things along those lines. Circumstantial evidence is something that the judges best describe in a jury charge, which would read something like this. Members of the jury, imagine you arrive in a building and it's mostly cloudy outside. You go inside, you're in an inner office with no window to the outside world. An hour later, a person comes in and they have an umbrella that's wet. They're followed 15 minutes later by another person who has a raincoat on and it's dripping water. More likely than not, is it raining outside? And the judge would ask the jurors to draw from their personal experiences. That is an example of what circumstantial evidence is. A judge would then tell the jury that circumstantial evidence is of no less probative value than direct evidence. So I'm going to be saying today many times, look for inferences. Basically, what a court looks for, are there enough inferences so that you can find out more likely than not that there is some form of discrimination. The first part we're going to talk about is hiring and promotion. And of course, I don't need to tell you that there's a difference between hiring and promotion. But in the world of employment law, it's a very big difference because in promotion cases, there's an added level of due diligence that HR needs to handle. And that's because that the employee who's being promoted or is seeking a promotion has an employment history and track record with the company. And we have to be careful of potential claims of retaliation. Retaliation is a complaint made by an employee, whether to HR, to a supervisor, to the EEOC, or in court, of discrimination, that the employer knows about the complaint, that there is some sort of an adverse employment action against the employee, and there is close temporal proximity between the complaint and the adverse employment action. Employers are at risk of claims of retaliation in hiring and promotion. Hiring cases could be a couple of different types of claims. One is where a person, and this is actually a real case in Dallas, a person sued his employer for discrimination, and then he applied for a job with a different company. When that company would not hire him, he sued that company and claimed retaliation. Now, he was unsuccessful in that case because he was not able to establish that the company knew about his first lawsuit. So knowledge on the part of hiring managers is very important. And there are times where less is more, because you can gain knowledge about things such as a prior lawsuit in the application process, during the interviews, and if you go online to look at information on a candidate. So a former employee can also claim retaliation, and this would occur when, for example, an employee brings a lawsuit against a company and the case settles. And then a year or two later, they try to apply for a job with the company. Again, they're not hired, and they claim it's because of discrimination for the first case. Retaliation promotions is an area that's a really difficult area to navigate for employers. And this happens when an employee makes a complaint of discrimination and still works for the company. And now there's a situation where there's a promotion that becomes available, and the employee seeks that promotion and is not given the new job and claims this was retaliation. It's very important to make sure that the left hand and the right hand know what each other is doing. And HR is the best suited to coordinate that process. Make sure that HR is aware of all complaints by employees of discrimination, and when that employee is applying for or seeking to be considered for a promotion, HR knows about that and then develop a strategy to minimize any inferences that can be drawn by that employee. Now, when we decide that we're going to hire people, it's so important to have a strategy. As people in the hiring business, you want to know as much as possible about a candidate so you can find the best person for the job. At the same time, the employment laws make it dangerous to know certain things about candidates, because that could create claims by the candidates that they were not treated fairly because of whether it's a prior complaint of discrimination, whether it's gender, age, race, religion, national origin, ethnicity, disability, military status, etc. So asking questions about prior litigation basically is playing with fire. And sometimes it's true, less is more. You want to know the things that are important to make the decision without knowing the things that can get you in trouble. Again, our goal is safe hiring and promotion practices. Candidates oftentimes judge the process based upon perceptions, and they talk about things like notice. When they go to visit the lawyer saying, I wasn't treated fairly when I tried to apply for a job with X Corp, they're going to say the notice, I got short notice, or the notice discouraged me from applying. The qualifications that are required are too restrictive. The application contained things that shouldn't be asked. The process, where the interviews took place, who was selected to be interviewed. The people on the panel, it was not a fair panel, and the questions asked were not fair questions. An example of a complaint about an unfair panel would be if everyone on the panel of interviewers on first or second or third rounds are all males, and a female applies and she doesn't feel she's been treated fairly, or if everyone's white and an African American applies. That's an example. The candidate will compare himself or herself to the other candidates and try to draw favorable inferences. And the last but not least, they talk about statistics. Example of statistics would be 50% of mid-level managers are female, but when you get to the upper-level management, only 4 or 5% are female. What happens along the line? Statistics like that, basically becomes a red flag of a potential problem. The company's policies regarding the hiring and promotion practices should be thought through carefully and then properly communicated to people. Think about things such as, do we base promotions on seniority? If the answer is no, maybe it's a good idea to put that in the policy manual, that we don't base promotions on seniority. We have a different set of criteria that we use. What is the process for promotions? Can all the people who are interested in the position apply? Can only people who are invited apply? Is it seniority driven? Are promotions given based upon a tap on a shoulder? That practice is not as common now as it was maybe 10 or 15 years ago, but back then there were so many cases I was involved with where people would only be promoted based on a tap on the shoulder, and the people who were never tapped felt it was very unfair. How do we select candidates for interviews? Are we interviewing people who are the ones who met all of the required qualifications, or are we interviewing some of the people who met some of the requirements but not all, and are we being selective in that part of the process? Again, that can go to inferences of discrimination. How do we conduct the interviews? Are we doing them in a conference room for some people, in an office for another person, in a more informal setting for a third person? What about nepotism? Although nepotism is not illegal, it does make for an angry workforce, and those are people who would be looking for any inferences that they can bring to a lawyer. Are all candidates educated on the process? Are we clearly explaining the process that our company is using for promoting people? Now, when we talk about required qualifications, the EEOC has jumped in several lawsuits in the last couple of years where they have put under a microscope the required qualifications for major companies in hiring. And they have scrutinized whether we have a schedule that we say people need to be available to work that's realistic, because maybe we're trying to exclude working moms by saying that people have to be available until 8 p.m. or 7 a.m. when the working moms can't get there. Physical fitness. Are we asking for candidates to be able to do things that they would not have to do in the real world, but they have to be able to do that in the application process? Are we being too restrictive on the education? And the EEOC has said in some cases that if we're too restrictive, then we're trying to force out people who are minorities, because minorities tend to have less of an education. That's the EEOC speaking and not me. And also whether or not people really do need to have certain levels of experience for positions that they're applying for. The application that we use for candidates for jobs also comes under scrutiny. Candidates should not be expected to disclose their age, religion, disability, marital status, and whether or not they've got children on their applications. Unfortunately, there are applications that are available through some companies and online that have dangerous categories in them. And this has led to massive problems for some companies, and unfortunately the companies were innocent in the process. They buy an application, they use the application, and they did not realize that some of the questions were inappropriate. Some of the applications actually ask for a candidate's date of birth. A common question on some of the applications is to ask a candidate when they graduated from high school. Now, most people graduated from high school at 17 or 18, so that's how you get to know how old your candidate is, and that really is just an inappropriate question. Some applications ask if someone's ever been arrested. List your disabilities. Are you available to work on the weekend? These can be dangerous questions. Another thing that companies do prior to selecting the candidates for the interview is they like to go online. Hey, Marty, let's Google the candidates. Well, is it a good idea to Google candidates? Well, the answer is it depends. If you go on to, let's say, for example, LinkedIn, and you look at the references for a candidate, and you get to learn more about the candidate, that may be very helpful. But if you do more of a general search online and you find out that the candidate has cancer, now you've got a major problem, because if that candidate has cancer and you don't hire that candidate but you knew about it, they can claim that's discrimination. So what's the best thing to do is, if you're going to go online, be very careful and selective where you go, and also weigh the potential gains versus the risk of Google or other resources online. On the last but not least on the internet process is there actually was a case where a company demanded that a candidate show the interviewer her Facebook page. And that led to horrible publicity and, a litigation case. So, be careful again in how you use the online tools. Now, the process has got to be transparent, and it's so important that you, again, view this from the perspective of the candidate and potentially a trier of fact, whether a judge or jury. There was a case where a town was looking to hire a firefighter, and the best candidate for the position turned out to be a female. The town never had a female firefighter before, and they did not want a female firefighter in the worst way. In fact, they already had told a male candidate before he even interviewed that he would get the position. But as they went through the different levels of the process, the female was coming out as the best candidate. So they delayed the process, they hired a consultant, and they tried to find some way with the consultant to get rid of the female candidate. And then they even directly discouraged her from seeking the position. The end result, they ended up in a major lawsuit with strong liability. One of the tools that many of my clients use in screening the applicants before interviews is called a applicant flow chart. You list the names of the candidates, like in this case Bob, Robert, and Bobby, and you number the required qualifications for the position. Indicate whether or not each of the candidates has met all of the required qualifications for the position, whether or not they were interviewed, and who's offered a job. It's a good way to organize the information that you've gained and something that you can maintain as part of the records, which we're going to talk about in a few minutes. Now we've got to come up with a good plan for how we interview the candidates. And I know I touched on it earlier, but location is very important. Some people like to do interviews in hotel rooms, others in a conference room, in their private office. Whatever approach you're using, make sure that the approach is appropriate, that you do not expose yourself to any kinds of discrimination claims, and that you use a consistent process for all of the candidates being interviewed. Who should be on the panel? If it's possible, make sure that the panel has got, it's a diverse panel, male and female, different backgrounds in the company, HR and a hiring manager from the department. Diversity is also important. Prepare for the process. How are we going to interview? How are we going to create our papers for it? The questions we're going to ask. Think it through early on in the process, and then schedule the interviews. One of the inferences that can be drawn, and this has come up in lawsuits, is that certain people who were being given an opportunity to be interviewed, especially in promotion cases, who felt they were not being fairly considered, get the offer for the interview last minute, or the interview is scheduled for a time when they're not available. Teach your members what they can and cannot say during the interviews. It's very important that they're not telling somebody, like in that firefighter case, you've got a job before the process starts. Now, also prepare the panel for those times when a candidate volunteers information. What are you going to tell the candidate? The candidate says, oh man, I'm having such a hard time getting a job ever since I had my last child. Politely say, we didn't ask you about whether or not you've got children. Please don't volunteer information like that in the future. Thank you very much. And also, is the same person asking the questions of each of the candidates? This is ways to avoid inferences, as we talked about earlier. Interview questions. Some people shoot from the hip. Others prepare questions in advance. I prefer that questions be prepared in advance so that you avoid the risk of asking questions which would lead a candidate to disclose information such as age, religion, disability, etc. Now we're going to talk about a couple of the questions that people use. One of them is, what are your hobbies? And then the next question we're going to talk about is, what did you do to prepare for this interview? The question of what are your hobbies? The first thing I would ask is, what information is gained from asking the question? Well, a person might talk about fishing, golf, tennis, sports. Maybe they're going to talk about cooking. Maybe they're going to talk about their children. Maybe they're going to talk about activities at the church they belong to. Because it's such an open-ended question, the risk of talking about children or church or things like that is too great to ask such an open-ended question. And also, there are many jurisdictions where it is unlawful to make employment decisions based upon what a person does in their free time. The question, what did you do to prepare for the interview? Are there any risks in asking that question? There are no risks I can think of in asking the question. But the benefit is we can learn whether or not this candidate is really serious about the job. How resourceful was she in preparing? What, is her internal locus of control? Is she somebody who, when she sets out to do something, she gets it done? Does she actually take the time to prepare? Now, what about a question such as your ability to work on the weekend? Be careful with a question like that because of the fact that if your company is an insurance company that's a Monday to Friday, 9 to 5 kind of outfit, why would you ask somebody if they are able to work on the weekends? And compare that to, let's say, Macy's, where people, work 7 days a week, and they're oftentimes open until 8 or 9 o'clock. So in your company, ask whether the person who had the job before this opening came up worked on the weekends. Is it foreseeable that there will be a need to work on the weekends? Because if you're asking whether or not a person can work on the weekends, you may be getting at things such as the religion, where in some religions they're prohibited from working on a Saturday or a Sunday, or perhaps they get into child care issues. So be careful while you're asking the question, but not just from your reason for asking it, but what the candidate might claim your reason is. Again, we're talking about inferences. Timeliness. We all want our employees to get to work on time. There's nothing more frustrating than a person that's routinely showing up 15 or 20 or 30 minutes late, and bad time in attendance is not good for productivity or morale in the company. No question about it. But if you ask one candidate based upon a suspicion gained during the interview process about whether that candidate has problems with time and attendance, but you don't ask other people, now you're running a risk that someone could claim I'm being treated differently because maybe it's minority, my age, my gender, the suspicion I'm a working mom, whatever the reason might be. The way to avoid that inference is to simply make sure that if time and attendance is important, ask it of all the candidates. Honesty is a two-way street in the interview process. It's so important to be realistic in talking with the candidate about the position and the company and the responsibilities. If culture in your company is important, create questions that get to culture that are probative and make that part of your interview process for everybody. Now, there's a concept called locus of control and internal and external locuses of control, which is part of a motivation-based interviewing program. And basically what this gets at is asking questions that really go to whether or not this candidate can do that job. So for example, asking the candidate, are you good at handling tough customers? The candidate's going to say, yeah. That's not a very good question, but you need to know whether or not a candidate is good at handling tough customers. A better question is, tell me about a time when you had to work with an angry customer. Follow up with, what did you learn from it? And then follow up with, how could you have handled it better? Now you're forcing a candidate to talk about a specific instance where something occurred. This is not something that a person would prepare in advance, and they would have to come up with a candid, open response to a real question. Now also remember that honesty works both ways. Again, you want the candidates to be honest in answering the questions, but you've got to make sure that you're honest in describing the position and the expectations. Now, what do you do with the answers that you get? Do you have a consistent method of recording responses? If you have written questions, are you writing down the responses next to the questions? Are you writing on the resume? Do you have a consistent method of rating the responses? Do you rate them A, B, C, D? Do you rate them 1 through 5? You know, good, bad, what are you doing? If you're weighting some responses over others, make sure that your scale makes sense. So say, for example, if you're trying to emphasize a person's ability to deal with a technical subject, that should be graded higher than other categories on that interview process. If you have a team of people conducting the interview, are they meeting together to record the responses and grade the responses, or are they doing it independently? Sometimes if they're all coming up with the same grades, that's an inference of collusion in the interview process, which leads to the allegation that the person who got the job was decided on before they ever had the interviews. And the last thing is, what are your policies with respect to notes that are taken during interviews? Because the interview records could be discoverable in a lawsuit. These dangerous comments appeared in cases that I've been involved with that were litigated. This was several different lawsuits where these comments were made, and these cases all settled after they were brought prior to trial for a substantial amount of money. Yes, these comments are all true. Pregnant? No. Married? Too bad. I think that you can't work on Saturdays. Hot? Yes. Not our color. I think that guy has Alzheimer's. Believe it or not, people wrote these things down on interview records. Now, it's so important that we make sure that we look out for potential retaliation. Make sure that we are keeping appropriate records. And these records need to be maintained for at least 7 years. The longest statute of limitations I can think of is 6 years. And add a year just for safekeeping, and you should be safe. Now, if you don't keep these records, there could be a time where this is held against you in court. There is a jury charge that says, members of the jury, the records which were requested by the plaintiff should have been maintained by the defendant. The fact that the defendant did not produce those records can lead you to believe that the reason they were not produced is because they would have hurt the defendant's position in this case. So also, please view the interview process from the perspective of the employee candidate and your company and a third party who might be a trier of fact on a case. There are unexpected issues that arise during the interview process, such as a disclosure of a need for an accommodation for religious or physical or medical reasons, a prior criminal conviction, a spontaneous statement made by a candidate. An issue arises that forces the interviewer to step out of the room for a few minutes. If any of these things happen, it's not just how the interviewer handled this situation. It's also what did the interviewer say and what was the interviewer's body language. Again, we're trying to avoid inferences that can help the candidate. Bad body language is almost as dangerous as a bad comment. So please prepare the people on the panel for unexpected issues. One of the things that many employers do now is background checks. They're looking for information on prior criminal records, maybe bankruptcy, things along those lines. There are a host of federal and state laws that govern the process of what can be obtained and what you do with the information that's been obtained. So please make sure, for example, that you are familiar with your obligations under the Fair Credit Reporting Act and state laws such as Corey in Massachusetts that govern the information that you've received in your background checks. And then also be careful about what you do with it. For example, a blanket rule that says that you will not hire anyone who's been convicted of a crime in many companies would be a violation of Title VII. And the EEOC had brought a case against Pepsi-Cola for that policy years ago. Similarly, it may be against the law to refuse to hire because the person has a prior bankruptcy. Okay, so now you've decided on your successful candidate. And the next question is, what do? Do you tell the unsuccessful candidates first? No. First, you want to make sure that you've got your candidate and your candidate has accepted the job before you tell your unsuccessful candidates. What do you tell your colleagues? Be very careful. Don't say things such as, I'm really happy. We've got a young person in the job here. Be careful about that. And also be mindful of the fact that in promotion cases, you may have one very happy person, but you've got a lot of unhappy people. Now you want to send an offer letter out to the person who you've selected for the job. Be very careful to make sure the offer letter talks about it being an at-will position and talks about salary, title, and minimal information. There is a case recently where an offer letter said, congratulations and welcome aboard. You will receive $75,000 per year for the 3 years. You will not be eligible for a raise. You will work as a director of purchasing. And what's wrong with this? Well, they wanted to get rid of this person 6 months or so after he started, but he said, no, I've got an employment contract. And the court found it was a 3-year employment contract, and they had to pay the person for 3 years. Now, again, let's avoid the following pitfalls. Don't promise duration of employment. Don't promise growth. Be careful of ambiguous terms, especially when you're talking about a position where there is a base salary and commissions. Make the terms clear. Be careful about unrealistic expectations. If you make an offer of employment, make it for a finite amount of time. You must accept this position by September 30. If you make it open-ended, you can run into problems. And also, don't hold the person out as being part of a partnership or an ownership in the business. I've defended that case, and it created a lot of angst for a client. Again, please watch out for retaliation. Look at statistics objectively. Make sure that we're hiring, as much as possible, a diverse workforce, and taking into consideration all of the protected categories. Make sure that your policy manual is adhered to, that your policies and procedures are adhered to. View the process from all sides, and please don't create emphasis that don't otherwise have to be created. I did want to touch briefly on contracts. The one advantage is they do create a mutual commitment. It is a vehicle to create non-compete provisions. It can include arbitration clauses, and it can also include when a person's employment will be terminated. Non-compete agreements are very, very important in certain kinds of jobs because they protect against solicitation of customers and clients, trade secrets, solicitation of employees, and also disclosure of sensitive information. They can contain things such as choice of law provisions. In a nutshell, if the non-competes vary greatly from state to state. If you have a non-compete that's a 2-year-long non-compete and you can virtually shut this person out from any kind of employment during that period of time, that's not as likely to be upheld as a non-compete that maybe is 3 or 6 months long, and the person can work, but not in your profession and competition, and the person can get a salary that's close to what the person was making before. But the courts do look at duration. They look at the restrictions. Can this person work at all, or they only can't work in this given specified area of let's say, manufacturing or research and discovery, development, excuse me. Final tips. Please make sure that you train all the people involved in the process. Do your best to have the broadest possible pool of candidates. Make sure that you're make sure that you are not unnecessarily excluding candidates. Ensure the applications are appropriate, that you're not asking for things such as the date that the person finished high school. Make sure that your process is consistent for all of the candidates. Maintain those records for at least 7 years. Make sure that you're compliant on background checks. Look at the process from the perspective not just of the company, but of the candidates and a third person, especially somebody wearing a robe in a courtroom. And it makes good sense to audit your process. Thank you so much for attending the webinar today. If you've got questions regarding your applications, your interview process, a question you're asking, a promotion process, or you want to talk about making sure that your people are properly prepared and trained, feel free to reach out to me. Thank you very much.
Thank you, David. That was very informative. And thank you to everyone for attending this webinar. A recording will be available on the Wagner Law Group website shortly. Please feel free to contact David if you have any questions or if you'd like him to train your managers. We hope you'll be back for our next webinar. Thank you very much.